All right, this is our Unit 5 review, which covers federal courts, civil liberties, and civil rights. Please excuse any interruptions. I think we might get a bell at some point during this review session. So let's usually start with federal courts, thinking about kind of levels federal courts. Remember that most cases are actually heard at the district level or at the state level. They never make it to appeals. And I think it's something smaller than like 10% ever actually get appealed of all the cases. Even look at like the Supreme Court numbers. They literally get 5,000-7,000. I've heard upwards of 10,000, and they only take anywhere from 100 to 150 a year cases they actually hear. So we're thinking about those federal courts. Kind of the important idea is that the whole thing about courts can be found in Article 3 of the Constitution. Lucy each, jolly ranchers and cooks rats. Lucy each, jolly. So third article, and it's very short and pretty much gave Congress the ability to create more courts as needed, including setting up more members in the Supreme Court. We're thinking about courts, kind of that basic view, judicial review. It's kind of the basic power that they have, and that allows them to interpret not only laws but also acts or anything done by the president to be unconstitutional or constitutional, or evaluating that. Also keep in mind the Supreme Court is the only court that has both appellate and original jurisdiction in the United States, because they do have certain cases that start in the Supreme Court. The majority of cases that they hear, of course, are appellate. In order for the Supreme Court to hear a case, 4 out of 9 justices have to want to hear that case, and they then are given a writ of certoria. Once they get a writ of certoria, then people will begin to write the amicus briefs. The lawyers will actually present in court before the Supreme Court. When they get a hearing date, they're put on the docket. They only get to speak for about 30 minutes, and the Supreme Court justices can interrupt them to ask them questions. Remember that they're looking at kind of the constitutionality of the law. And in the appeals courts in general, they're not deciding guilt or innocence. They're just looking to see, was the letter of the law followed. When the Supreme Court actually makes a decision, there's the majority opinion, and then a justice could agree with the majority opinion but for a different reason, and that's called a concurring opinion. If they agree or disagree, then they would write a dissenting opinion. And they describe in those opinions why they agree or disagree. Obviously, if it's unanimous, there's just one opinion. That's one of the few jobs the Chief Justice has, is to actually decide who writes the majority opinion. When the justices are selected, or federal judges in general, we're talking about justices, we're talking about the Supreme Court. Judges would be other federal courts that are serving federal courts. And when the president makes those appointments, the Senate has to confirm them. And senatorial courtesy is where senators, if they're being appointed for their state, they can speak up and say, yeah, I don't want this guy. And that could keep them from being approved. And they have to have a reason, but they give a courtesy to the person who's from the state that the judge is meant to be serving at. And we know that the process right now has been delayed for a Supreme Court justice nomination since Scalia died, and we haven't replaced that. The president, of course, will look to pick someone who believes supports his party's ideals. Maybe he's looking to fill a position based on gender or minority status. But additionally, they would also, maybe pick people who could easily get through the confirmation process. They don't want to pick someone who specifically would be really challenging to get through the nomination process. All right, I'm going to kind of move on for that because it's just kind of your basic stuff, and let's get into the nitty-gritty of civil liberties and civil rights. So our key words that we need to remember are selective incorporation, civil liberties, and civil rights. So remember that selective incorporation is the process by which the Bill of Rights have been applied to the states over time. So keep those three things in mind. We're applying it over time, case-by-case basis, applying the Bill of Rights, and it's to the states. Okay. Additionally, we're specifically talking about the first 8 amendments that have been applied, and the first case to actually apply them would be Gitlow versus New York, which says, hey, selective incorporation does exist. You're not just a Virginia citizen or a New Jersey citizen and a federal citizen, because that's what they had said before, Barron versus Baltimore. You have U.S. rights and then you have your state rights. they're now saying, yeah, the Bill of Rights does actually apply to the states, but in this particular case, this guy's freedom of speech, the government had the right to censor it. He doesn't get freedom of speech in this case. When we get a little bit further, we're going to actually start to see cases that are selectively incorporated, such as Miranda versus Arizona, Gideon versus Wainwright, Matt versus Ohio. There's really kind of my go-to cases. And those are dealing with civil liberties. So remember that civil liberties are to protect us from government action. It's protecting our basic rights from the government infringing on those basic rights. But again, that's the key part. It's protecting us from government action. Then civil rights, on the other hand, are protecting groups from discrimination and the things that we would think about: race, gender, ageism has been an issue as well. And today we're really kind of defining where does LGBT status fall in there? Where does sexual orientation fall in the civil rights kind of category? So let's start more with civil liberty. Let's go back again to selective incorporation. And so let's start with Gideon versus Wainwright. Gideon versus Wainwright applies the Sixth Amendment, the right to a lawyer, through selective incorporation. Miranda versus Arizona, that's going to apply the rights of the accused, which covers both the Fifth Amendment and the Sixth Amendment. You have the right to remain silent. Anything you can say will be held against you in the court of law. If you cannot afford a lawyer, one will be appointed to you. You have a right to attorney, all those good things. That's done through Miranda. Matt versus Ohio is another interesting selective incorporation case with Miss Dora Lee Matt. And in the selective incorporation case with that one is exclusionary rule. And basically, we're talking about Fourth Amendment search and seizure, that if something is gained illegally in a search and seizure during an investigation, it cannot be used in court. It has to be excluded. That's what the exclusionary rule is. So there's kind of three examples related to First Amendment rights, thinking about those, related to right to the accused. Other cases we want to know that deal with civil liberties would be First Amendment cases. So, for example, First Amendment, we have freedom of speech, religion, press, petition, and assembly. Now, speech has two parts. Speech has three types. We have pure speech, speech plus, and then symbolic speech. So pure speech is you're just talking, and then we have symbolic speech, which is like burning a flag, some kind of symbols involved, and then speech plus is that action part, so petitioning, picketing with a sign, and also saying something. With our big speech cases, it's very important to understand that political speech is very protected in our country. Like even when we look at like Snyder versus Phelps with the whole Westboro Baptist case, the fact that while we may hate what they're saying, they still have the right to say it. Now, when you think about schools, where does this apply? Tinker is our huge case, Tinker versus Des Moines, that just because you step foot on campus, you have not shed your rights at the gate. You still have rights as a student, as a teacher, when you get onto campus. But they can be limited, and so we're looking to see, are you causing a disturbance? So in Tinker, with the black armbands for the Vietnam War, they were not causing a disturbance, therefore it was allowed. Although like Bethel School District versus Frazier with the young guy giving a speech, his was considered to be disruptive. Or the Bong Hits for Jesus case, Morris versus Frederick, his case is considered to be disruptive as well because he's promoting illegal activity. That's why his free speech isn't protected. When we think about religion, specifically, there's two clauses. So we're looking at free exercise and we're looking at establishment. With free exercise, do you have the right to practice something? So Reynolds versus the U.S. really sets this up with that there's a difference between belief and practice. Well, I can believe whatever I want, but I can't necessarily practice that. And then with the establishment clause, there has to be limits. The government, we have very strongly believe in separation of church and state, and so the government cannot be trying to establish a religion. So the big case of that is Lemon versus Kurtzman, which sets up a case that said this is a three-pronged test that we're looking at, that you can neither promote nor inhibit a religion, and there cannot be excessive entanglement. So, there's lots of cases that are challenging this. It's okay for states to give money to schools, private schools that are helping to provide funds for transportation or books. Those things are okay that are related specifically to the education kind of basic needs for children. The other things are not okay, like the teacher subsidy case that we looked at, those kind of things. When we're just checking to see if there's any other cases I want to make sure I cover, we talked about that, and then we'll move on. Let's talk a little bit about right to privacy. Real quickly, I'll mention with speech. Texas versus Johnson, that's symbolic speech. It's okay to burn a flag because it's symbolic speech. All right, right to privacy is not specifically mentioned in the Constitution. It is implied. It is implied often through the 9th Amendment. We have rights that are not listed. Through the 4th Amendment, search and seizure. Through the 5th Amendment, those are rights of the accused that we have. Some people even argue 3rd Amendment, the quartering of troops. And the establishment of the right to privacy is Griswold versus Connecticut, which was that contraceptive case, like whether or not doctors could prescribe birth control. It is further extended in Roe versus Wade, which is the legalizes abortion. Since then, there have been limits on abortion, which there have been cases. Planned Parenthood versus Casey says it's okay to put restrictions on abortion as long as they are reasonable. And that's, we can't make you have a 3-month waiting period to have an abortion, but we can say you can wait 24 hours. It's okay to have parental consent, those kind of things. All right, other cases to think about, Engel versus Vitale, or Vitale, I never say it correctly. This is the one that ends school prayer. And then let's move on to some civil rights issues. So we have the Civil Rights Act of 1964 that was passed that's working to end discrimination. And that applies not just to minorities of color, but it also applies to women. And that's important to remember that it works to end gender discrimination as well. Reed versus Reed is the first court case to really deal with gender discrimination. And this was the brother and sister who were arguing about the executor, who could be the executor of the estate. But it's the fact that's saying that it does exist. And the court says there can be reasonable discriminations. For example, you can't vote until you're 18. That is an age discrimination, but that is okay. When we think about discrimination, how it existed, we had de jure and we had de facto. So those were happened de jure by law, which is what was happening in the South. And in the North, it was de facto segregation, which is because of where people were living and those kind of things. The Jim Crow laws that were set up in the South were specifically to keep people from voting. We had poll taxes. There were literacy taxes, literacy tests, which were extremely hard. You missed one question at a small time. They were meant to keep African Americans specifically from voting. Additionally, there was the grandfather clause, which you could only vote if your grandfather had voted. There was white primaries, which if only whites are voting in primaries, then who are your candidates going to be? Lots of things that were done to impede African Americans from voting. So the Voting Rights Act was passed to help end that. So we have the Civil Rights Act. We also have the Americans with Disabilities Act that was passed. This is another thing that's trying to help end discrimination. We're thinking about cases for discrimination. Think Brown versus Board of Education, which ends segregation in schools, versus the Heart of Atlanta motel case, which ends segregation pretty much period, because they use the Commerce Clause to say that businesses cannot discriminate. And so that pretty much applies to kind of everything. All right, let me kind of look over our little review sheet here and make sure I haven't missed anything. Real quickly, amicus curiae briefs. Those are the briefs that Friends of the Court that, hey, ACLU is bringing the Brown versus Education, but I also think that segregation is wrong, so I write amicus curiae brief. Writ of certiorari, that's actually issued when your case is going to be heard at the Supreme Court. Stare decisis is let the decision stand, which is what almost always happens in appeals case. That's just keeping the precedent that has already been set. You're not overturning anything. Brown versus Board of Education is a great example of judicial activism, because they're setting a precedent. They're overturning Plessy versus Ferguson. And so that's judicial activism, kind of taking a new stand. Judicial restraint is, well, we're just very much looking at precedents, kind of what we've done in the past. All right. Selective incorporation we talked a lot about. Remember that selective incorporation is in the 14th Amendment Due Process Clause. So remember, applying the Bill of Rights to the states over time, case-by-case basis. And it's the 14th Amendment Due Process Clause. Appellate versus original jurisdiction, we mentioned. Jim Crow's law. Affirmative action, didn't mention this one. Affirmative action is an attempt to provide more opportunities that have been denied to minorities. And this is encouraging colleges and workplaces to increase their number of women and minorities. And we have since said that in the California, Regents of University of California versus Baca, however you say it, that quotas are not okay, but affirmative action is. So the Supreme Court is continuing to uphold affirmative action. I would also say, remember that the Supreme Court continues to say that prior restraint exists, which is the fact that the government can censor what the press says, but in every case they always say it exists, but in this instance they couldn't be censored. So they want to continue to say that they should have it, but it is a protection of free speech that the Supreme Court does continue to provide. Libel versus slander. This is again, slander is spoken, the S's, and then libel is written. We're saying lies about people. It's very hard to prove. And remember, when you're trying to prove it, there's a difference between a public versus a private figure. So if this is one of the reasons that Jerry Falwell and Hustler versus Falwell had a harder time versus if I sued somebody for libel or slander, because I'm a private figure, he's a public figure. Also, if it's so outlandish and nobody would believe it, that's the other thing that hurt Jerry Falwell, is that no one would believe what was being said kind of about him. All right, we've hit all the court cases. We know our amendments. We know our types of opinions. Search and seizure exceptions. So if there is, if it's in plain sight, if it would have been found anyway, that whole kind of good faith clause, if I thought he was doing what he was supposed to be doing, those are exceptions to the search warrant that you need based on the Fourth Amendment. All right, pretty much that's everything you need to know. I would focus when I'm thinking about reviewing for my FRQs, selective incorporation, what it means, where it's found, what are examples of selective incorporation. It's also good to keep in mind why and how the Supreme Court justices are chosen, and what is it about the Supreme Court justice, why do they serve for life? That's an important concept as well. The idea that we need to have them isolated from kind of the public, and that they don't need to feel the pressure of being reelected. They typically do not choose cases that are very hot topic. They try to avoid those kind of questions or kind of topics. And they are almost generally in line with public opinion. And so they're really not that far off in those decisions that they are making. There are 9 members of the Supreme Court. That's how many there's supposed to be. Currently, we only have 8 because since Justice Scalia passed, he has not been replaced. And I don't see that we'll have one before President-elect Trump takes office in January. Good luck on your test.